the workflow with reference to the patent applications in India, just like say what will be the your workflow with reference to that your patent in India. So now I referred already to you the patent right is territorial right. What is the meaning of that? That your Indian patent is only valid in India. Okay. So for virtue of that, so now you want to establish your business in China, but you have a patent in India. So you always have to be in fear of two ways. What are the two ways? You may came up with a situation that you are infringing somebody's patent in China. Okay. And another situation, let us say you will pay this thing is in say in a consideration in the form of a public good in China. Okay. So if it is a public good in China, so other competitor also can produce the same product in China. So you have to face the consequences of competition in China. Somehow you will not able to use your power, sometime we call dominant power. So sometime you patent give ultimately give a dominant power in a particular market. Although you should not use your dominant power, but you will get a dominant power in the market if you have a patents. Okay. So understood that you have got the patent in India, you want to ultimately establish a business in China, then what threat you have? First means you will not having dominant power in China, you have to face competition in China, and another threat that you may fear of that somebody have a patent maybe in China, okay, with reference to the same or similar type of invention, then you are falling in trap of that patent. So then you are infringer in China. Although you are a patent holder in India, but you are infringer in China. So definitely you will not want that. So considering that, you already told that. So we have a procedure or just like said for getting a patent in other countries also. Just like say Paris Convention you have heard about, you have heard about the GATT, you have heard about the TRIPS, the trade related aspects of intellectual property rights. Just like you have heard about WTO, World Trade Organization. So it is a say WTO is they can administer and enforce trade related aspects. So so similarly the TRIPS suggested a general framework of IP law. The country who are the member of the TRIPS, they can ultimately have to follow the minimum standards with reference to the IP law. Just like I referred a patentability criteria, now almost uniform. Who are the member of TRIPS, all the three criteria is there. So they have to minimum at least may follow, give some benchmark. If you are the member of the TRIPS, the minimum benchmark, they can go beyond that, but they should not go below that. So minimum benchmark have been prescribed by the TRIPS, and the country has to follow that minimum benchmark. Okay. So so there lies the international characteristics, international body, and so considering that, say Paris Convention and TRIPS. So if I now ask you how to will get a file patent application in other country. Okay. So there that based on Paris Convention, then subsequently we have a patent cooperation treaty, now patent law treaty, different types of treaty or convention. These are the called soft tool or international tools used for administering and enforcing something beyond that country's jurisdiction. Okay. So and with reference to the procedural aspects also, they make the system easier for applicant applicants also. So, definitely they have to create a framework. So based on that, these two routes you can presently available for an applicant of India, and subsequently on reciprocity basis. So, somebody can file patent application in other country. So, I have referred there conventional application and PCT application. I try to explain these two things to you. Okay. So, conventional application generally is coming based on the Paris Convention. So, Paris Convention you understand convention treaty, then convention treaty, it is called patent law, patent cooperation treaty, patent cooperation, cooperation treaty. Okay. So, these are the two soft tool or international tool it can be used with reference to the patent to get right beyond a particular territory with reference to a same invention maybe. Okay. So, the conventional patent application I will refer. Okay. I will explain that thing. So, let us say Mr. X has filed patent application in India, filed a patent application in India. Okay. He filed a patent application in India. So, now he is thinking about extending or thinking about creating his rights about the same invention in country like Japan, China, Korea, USA. Okay. So, now he has already filed a patent application. So, he got a date in India. Let us say today is 03/06/16. So, his date of patent in India, date of patent in India is 03/06/16. Okay. So, now, so how he will get able to create the rights in other country. You may ask me, you told that okay, novelty, inventive steps are industrial activity is the criteria in other countries also. So, now if we file patent application in Japan, how the patent application of Japan will be novel based on, because it is a prior claimed in Indian patent applications. Although the applicant or inventors are same, but already it is claimed in a prior patent application in India, then okay. So, then it will be a problem. So, the WTO or Paris Convention have come up with some guidelines or procedure or rules you may consider to somehow mitigate this problem. Okay. So, what they have, say guidelines or tools or routes or rules they have come up? They came up. Let us say you have filed a patent application in India 03/06/16. So, now using the conventional route, just like say conventional route, you can file patent application in other countries like Japan, Korea, but you have to thought about whether all are member of Paris Convention or not. Korea, China, USA. Okay. You can file patent application in other these countries also, Japan, China, Korea, USA. Okay. So, now how? So, they have told that if you have to file the patent application in all those countries within 12 months. Means 12 months from the 03/06/16 means you have to file the patent application by 02/06/17 in all those countries if you follow by conventional route. Okay. So, in that case the filing in India will be considered the priority, will get priority date. This will be considered priority date with reference to the patent filing date in this country. Okay. So, if you file patent application claiming priority of your patent application in India, then that will not destroy the novelty of the patent application in those countries like Japan, Korea, China or USA. Okay. So, in that case, that they told if you file patent application within 12 months from the date of filing the patent application in a country where you are so where you have filed the patent application first, okay, in that case you will not destroy the novelty of your invention, but you have to file the patent application within 12 months from the date of first filing the patent application in that first patent application. Okay. So, this is the conventional route, means advantage you are getting 12 months time to file patent application in the country who are the where you want to protect and who are also member of Paris Convention. So, this is the we call it conventional patent applications. So, when you will file the patent application in Japan, you have to tell my priority date is 03/06/16. When you file the patent application in Korea, you have to refer my priority date is such and such date, and you have to give the submit the priority documents, means whatever the patent application you have filed in India, that will be considered a priority document in Japan, Korea, China. You may refer that okay, priority document, so you may go to Korea with the two priority documents, means 03/06/16. Then based on that priority document again you have filed in Japan in maybe 03/07/16. So, you can reach here with two priority document in 04/08/16. Like this way you may claim multiple priorities also, there is no problem dearth of that, but the date of first priority document will be 03/06/16. So, conventional route you can use to file the patent application in a member country who are the member of Paris Convention. Okay. So, this is the conventional routes of filing patent application. Now, disadvantage of that, you have to go and file the patent application in the country India again, just like say again you have to file a patent application in Korea, Japan, China and USA, and also within 12 months. Okay. So, problem means individually again you have to file patent application, then that international body now administered by WIPO then came up with another treaty called Patent Cooperation Treaty, how that it make the system easier for the applicant. So, they have come up with a procedure called Patent Cooperation Treaty and some application called PCT applications route, or sometimes called International Patent Applications route. Although there is no international patent, but this is make a tool routes that make an applicant to get extend his right in different jurisdiction with ease, Okay, just I will try to explain the component or timeline with reference to the PCT application, although little bit complicated, but I will try to explain that thing. Okay. So, just like say you may come to the international filing in different ways also, just like say based on convention you may mixed some cases that conventional application along with the PCT routes also. Okay. So, or you may file a provisional application, based on that you are coming to the complete specifications also. Okay. So, let us say you are filing a provisional application in Indian Patent Office and 0 months means today, or you have filed a conventional applications means another you have a say application then you want to claim priority of that. Okay. So, let us considering that also. So, let us say that you have a claiming just like a provisional application, let us considering the priority, get the priority date. Now, within 12 months you are filing a international patent application or PCT application. Okay. Or you may come directly, you can also thought about filing a PCT application here. Okay. So, in this case say in this case directly you can go 0 to 12 without priority you are coming to the PCT application, or with priority you are entering into the PCT application. So, in this case 0 to 12 another 12 months you are getting, or you may directly file an international patent application in India Patent Office, in the considering Indian Patent Office as a receiving office. Okay. So, you are filing a PCT application directly in India. Okay. So, you are filing a patent application directly in Indian Patent Office as an international patent application. Okay. So, now what they will do, say if Indian Patent Office is a receiving office, so they will transmit your applications to. So, you have what application fee you have to pay? The application fee, transmittal fees you have to pay here. So, what fee? International application fee you have to pay and transmittal fee. So, they will ultimately check formality as per PCT rules, and they will transmit the things, your application, to the IB, International Bureau. Okay. So, International Bureau, and I forgot to mention here, you have to again pay another thing called search fee, and you have to mention which search agency will ultimately you are choosing for, to that agency will provide a search report. Okay. So, that receiving office will transmit your application to the IB. IB will now send your application to that search agency for international search report. International search report. Okay. And if you optionally are asking for a say international preliminary examination report, and you are mentioning an agency or same agency is doing for ISR also, same agency is for IPEA, no problem. So, then IB also transmit your application to the say search agency or also IPEA. Okay. When? Within 16 months. So, within 16 months they will send your application to the search agency and maybe IPEA. Then within 18 months from the date, means this is 0th month, if it 0th month is the date. So, from the priority date within 18 months, if it is 0 here, from here 18 months it will be published. Okay. So, already I told in a Indian Patent Office there is a opposition also. This is now called international patent publication, international publications. Okay. So, this is not say entry, that is not an entry in a national phase. So, this we are, the application is still in the international phase. So, authority is IB, International Bureau, or we may consider the WIPO is the authority with reference to that administering all those aspects of the patent applications. So, they will publish for international publication. Then you in this time you may receive the search report from the international authorities, international search authorities. Okay. Based on that, they may be, you may be allowed as specified in the PCT rules, PCT article 34, you may go for some sorts of amendment. That amendment part also again may be will be published, but amendment is limited by the article 34. You would not go, okay, such report is stating like this, I will completely change that. Let the amendment have been, the scope and limit of the amendment are already specified on that part. Okay. So, it will be based on that. So, publications then may be allowed to amend till 22 months. Some cases it is again published by the IB. Okay. So, then now you have to enter into the national phases within 31 months. Okay. So, it is running in the international phase till 30 months. After 31, within 31 months, you have to enter into the national phases. Okay. So, now in your international patent applications, you may set that okay, I am selecting all 130 member of the PCT where I want to protect my rights. Okay. So, that there is no problem that you may state that, or you may state that in 10 country I want to I am electing 10 country then for get my rights, get my patent to be protected. But the after say receiving the search report, after receiving all sorts of things, you have changed your minds, you do not get any partner in that countries where you are initially considering that I may protect my invention, you do not get any partner. So, now you are electing or selecting only maybe selecting only electing, we may consider selecting or choosing only maybe 5 country. So, you have to now you have to mention which are the country where you want to protect your invention. So, within 31 months you may have to you have enough time to choose for where you may want to establish your business. So, where you want to establish business, you have to protect your invention in that country in the form of patent to get a dominant position, or for fear to escape the threat of infringement in that country. So, you are choosing that country. So, then it will enter that IB will ultimately communicate your patent application to in that country. Okay. In that country, they will send the application in for that country. Okay. So, everything is administered by it, but you have to now pay the fees as applicable to that country. So, now fees as applicable to in that country you have to pay. So, first you have to pay international fee, then search fee, transmittal fee. Now, there was no fee till 30 months. Now, you have to, when you are entering the national phase, means now that as if you are entering in a US PTO, then US patent law will be applicable there, their procedure will be applicable here. So, after that say international phase, now you are entering into the national phase. So, now national phase means national law will be applicable with reference to your patent now. Okay. So, then US PTO, you are falling for EPO, you are going for JPO, and their law their act. So, Japan Patent Act, US Patent Act and European Patent Acts will be applicable to your invention now. So, what advantage? With this filing a single patent application, you will able to enter enter in the multiple countries. You are getting 31 months time to enter into the national phase. So, now this is your international filing date. Now, you will get a national filing date, national phase filing, national filing date for that country will be the. So, 2 date international filing date and national filing date for that country. So, within 31 months you have to enter into the national phase. So, you are getting 31 month time to enter into national phase. Okay. So, it is easier with a single patent application you are able to enter in a country in different countries. So, this is the advantage versus to conventional application, because conventional application you are have to independently file patent application in each conventional country, but here you are filing the patent application by single patent international patent application. You are able to enter into the multiple territory and to protect your patent right in a multiple territory by filing a multiple national phase applications. So, and you are getting 31 month time to select. You are getting an compulsory search report by International Search Authority. You are getting an internal, say you may getting say optional international preliminary exemption report from a particular authorities. Advantage for you by PCT application. So, if I ask what is advantages, I will say PCT will apply advantages, because cost and time time effectiveness is there in the PCT application as compared to the conventional applications. Okay. Whatever you learnt now, PCT application and conventional application, although another tool is available for you to file a patent application. Let us say you are not interested to file patent application in India, let us say industrial policy in India, you are Indian origin, Indian citizen. Okay. So, although the Act suggested Indian citizens should file patent application in India first, but if you are not interested to file in India, then say you can file patent application in other country, but in that situation you have to take permission from IPO. You have to take permission from IPO following the section 39 of Indian Patent Act. So, what way you can file patent application in other country? You may file patent application in India, then go following the PCT route or conventional route claiming priority situation, or you may have take permission file you simply apply before the controller in Indian Patent Office for permission to file patent application in other country. If you are a citizen of in India, then you have to follow that section 39, otherwise it may lead to the criminal offense. Okay. So, you have to first take permission from IPO. If you ask that me that if I apply for permission, that they are not giving me permission, you can have to wait a reasonable time. That time is prescribed in the section. I think mostly it is 6 weeks after filing applying for application for permissions to file patent application in other country. If you are not permitting, then you can if you are not permitting, not like that. If you are say not getting any response from them, you can go and proceed for filing patent application in other country. So, if I ask now what are the routes are available for an Indian citizen to get patent rights in USA, Korea, Japan and China, then without India, I am stating that without India, in that case first is take permission, then you can go and file independently in that country. But how will you get file independently in that country? In that case, you have to first get a priority from one country, or otherwise you have to file the same day in all that country. The time will be decided as per IST, international time frame, because time is, you know, that time there is a problem in the time frame. So, time will be considered as per IST, international standard time, IST standard time. So, you have to follow that and you have to file patent application in other countries. Okay. So, without that you will not get the rights in other countries. So, you can follow conventional route, file patent application in India, filing conventional route you can get the patent right in other country, or simply file a international patent application in the day 1 itself in India. There also you designate India and other countries, or you file a patent application in a form of provisional application, then a file an international patent application in India designating India. So, I forgot to mention designated, then elected. First is called international patent application is called designated country, then when you enter the national phase, then you will consider as a elected country, designated and elected. Okay. So, these are the routes you can follow for international getting patent international for filing patent application beyond your jurisdiction, means your own country. Similarly, the US citizens also can follow the routes of conventional application and PCT application and file patent application in India. You know that although situations have been changing, but most of the majority of the patent application in India by foreign applicant, either by means of multinational companies and others. So, foreign filing are more now PCT applications have been increasing in India. So, international filings people are using to file patent application in India. Okay. So, now I have referred just within a minute I am referring the international search report. So, international search report gives different, they may categorize, you search your patent application using the prior art search databases and categorize the different search document they will get by X, Y, like this. So, if some document they got it, then by virtue of that all features of your invention is available in that document, they categorize that as an X category of document. Then if document particularly if combined with other document, then Y category of document. So, that international search report will provide you the documents or prior art document which are directly relevant or highly relevant or relevant along with the other document to destroy the novelty and inventive steps or invention. So, international search report will give you an idea with reference to your invention's strength with reference to novelty and inventive steps. Okay. So, this is the class with reference to international of filing of patent using conventional route or PCT routes. You got an idea about international search report, you got an idea about the say PCT application, national phase, international phase and relevant time frame. You should remember that for to take to avail the root of PCT applications. Okay, so let's end it here. We'll further continue discussion on that aspects.